Is the appellant ready to proceed? Actually, this is the motion to dismiss filed by appellee. I apologize. So I will ask the appellee to go first and explain why the motion should be granted. It's an unusual argument. Thank you.
Certainly is, Your Honor, and I appreciate the clarification provided by the court a while back. May it please the court, Jim McKee, on behalf of the appellee movements, I'd like to reserve 3 minutes for rebuttal, and I will also be sharing 3 minutes of my time with counsel for the Department of Health. Now, as Your Honor mentioned, we are here on a motion to dismiss filed by the appellee movements, seeking to have this case dismissed on mootness grounds. Now, specifically, the underlying action, which was an administrative petition, challenged a decision by the Department of Health that approved a change of ownership, basically a change in shareholders by a licensed medical marijuana entity by the name of McCrory's. The action was filed in an attempt to prevent the closing of a transaction by the licensee's parent company, a recapitalization transaction. The thinking there being, if the department's approval of this change in shareholders could be prevented, or if it could be delayed, then the broader recapitalization transaction could not occur. Petition was filed. It was filed the approval was sought in 2020, November of 2020. The department approved the change in shareholders in 2021. Weiser subsequently challenged the approval, filed that administrative petition. The administrative law judge granted our motion to dismiss for lack of standing, determining that Weiser, the appellant here, did not have standing to actually raise his claims to challenge the approval. And the department issued a final order, and this is obviously the important facts here. The department issued a final order May 4th of 2022, denying, dismissing, essentially adopting the ALJ's determination that Weiser did not have standing to challenge the approval. That final order also denied a motion to stay, which had been filed by Weiser prior to the entry of the final order. Now, importantly, Weiser did not seek a stay from this court, did not seek review from this court of the department's denial of its stay motion, and instead filed a notice of appeal June 2nd, 2022, so almost 30 days after the final order was issued. Weiser took no steps in between to prevent the recapitalization transaction from occurring, to prevent the shareholder change from occurring. Ianthus, which is the parent company of McCrory's, the licensed entity here, closed on the recapitalization transaction June 24th of 2022, so almost a year ago now. So the change in shareholders, the very change that...
As I understand the appellant's argument in response to your motion, it appears to be that essentially this is such an important issue that the department acted improperly. Now, standing obviously is at issue, but that even though this transaction has been completed, the recapitalization, that the issue itself of when ownership is allowed, when the opportunity to challenge whether the ownership involves multiple MTCs, medical treatment centers, essentially that the issue is subject to, first off, that it's important, and that it's subject to reoccurring. Am I misunderstanding the primary focus of the response?
That is certainly the argument, and we disagree. And you're right. I believe it was, I'll probably state the wrong case name, but yes, there is a case that basically lays out exceptions to mootness, and those are two of them. We don't believe that this is essentially a question of great public importance that should be heard even if the case is moot.
But we're here on a motion to dismiss where essentially you have won as to standing, and now you are telling us, hey, we even have another justiciability argument that we'd like you to hear, but the facts of it are disputed. Why should we dismiss now instead of going forward? And if there are new facts, and your brother wins here and goes back, you can have it out in a place that can deal with disputed fact issues.
Well, certainly, Your Honor, if facts truly were disputed, if we were here with contentious facts that could not easily be determined, then I would agree with you. I think there'd have to be some sort of an evidentiary hearing. Should that really happen on appeal? Probably not. I don't think there can be any reasonable dispute that the transaction has closed. The recapitalization transaction It did close. June 24th, 2022, there was an SEC filing that said, hey, here's the new shareholders, this transaction is closed. There's press releases that were issued.
Now, your opposing counsel makes the argument that several of your assertions in the motion are based on facts outside the record, such as citing a website regarding the recapitalization.
And, Your Honor, I think that's consistent with this court's case law and case law of other courts considering mootness issues. Certainly, there's a number of cases where the court has determined, in fact, I would assert the entire doctrine of mootness on appeal. What you look at there is intervening issues, things that have changed since the final order was issued. So if we accept the argument that you can't dismiss a case as moot unless there's record evidence of why it's moot, you'd essentially be saying we can't dismiss cases as moot anymore, and that's certainly not what this court's done. It's not what the Florida Supreme Court has done. I believe even there was Canadian litigation that was referenced in the response, in appellant's response. That Canadian litigation, if I happen to pull up some of the documents, some of the filings, it doesn't assert that the closing did not occur. It's trying to unwind the closing, basically saying, sure, it closed, the transaction is closed. We're seeking to unwind the transaction that already occurred. So again, that's why I say I'm not sure there can really be any dispute that the transaction has closed. I think the argument is the transaction shouldn't have closed.
But it's a little more complicated than a suggestion of death. The appellant has died, and here's a death certificate, and basically it's an agreed deal, right?
Certainly more complicated than that, but I think the case perhaps that I would point to the most is Montgomery versus Department of HRS. I guess this is back before the name was changed. But it described, this court back in 1985, it described mootness as the doctrine of standing set in a time frame. The requisite personal interest that must exist at the commencement of the litigation, standing, must continue throughout its existence, mootness. One of the issues that we looked at in determining that this case is likely moot is the harm that the appellant sought to avoid was the issuance of shares which were going to dilute his interest. Those shares have already been issued. So the idea, even if, let's say, the department a year from now, 2 years from now, says we think that there's a dual ownership violation. We think there's a violation of this statute that says you can't have dual ownership. The remedy for that would be prospectively to say, you've got to come into compliance. If there's any dual ownership issues, come into compliance. Not, we're going to go back to a transaction that happened 2 or 3 years ago and somehow unring the bell. Let's try to put the toothpaste back in the tube. If you've got an equity, if you've got a change in equity.
Go ahead, I'm sorry.
Sorry, go ahead.
You go ahead.
Do you think that the appellant should have moved for a stay in the agency or this court or either one?
I believe they could have moved in either one,
Okay.
and there was a motion for stay that was filed prior to the final order being issued. So that was denied. I think that was untimely, but it was denied by the court.
So if the agency or this court had, say they did exactly what you said they should have done, they should have moved for a stay, and it gets denied for whatever reason. I can't think of a good one off the top of my head, but it gets denied. Too bad for them. They got their motion for stay denied. That then gives you the right to come in and say, without a stay, the appeal is moot, dismiss the appeal.
Well, certainly they could have sought review from this court. So they could have gone here. I believe they could go directly on an administrative case, but certainly they could have sought review of the department's denial of that
Denial of
motion
a stay.
to stay.
Well, go ahead.
If they choose not to do that, I would also point you to Florida Rule of Appellate Procedure 9.190, which pertains to stays in administrative cases. And it says, the filing of a notice of administrative appeal or a petition seeking review of administrative action shall not operate as a stay, and then it goes on to talk about some exceptions. The rules and the case law, I think, are very clear that there is a doctrine of administrative finality. Once a final order is issued, a party is entitled to rely on that final order. Certainly, there's also a right to appeal, but in the bid protest context, which we work in quite a bit, there's a number of cases that say once a contract is issued as a result of a government procurement, even if you ultimately win on appeal, if a contract's already been signed, there's no effective remedy. There's maybe some ancillary relief. Maybe you can get your bid costs. But these courts, this court and other courts have not said just don't worry about it, just unwind the transaction, just rescind the contract that's already been issued. I would submit that this is similar to that. I will turn it over to my colleague if that's all right with the court.
Good afternoon, Ed Lombard of Lombard Miles on behalf of the Department of Health. May it please the court. I'll just start with one of the questions that you asked Judge Osterhaus, and I think it, at least from the department's perspective, we agree it's moot, and here's why. The allegation below of harm, right, which is what they would like you to remedy, was dilution. That dilution has occurred. So even if there was a violation of the statute that you alluded to, Judge Thomas, and that was reversed, if you guys reversed and we went back down, the dilution can't be undone. And even if there's a violation of the statute in terms of dual ownership by one person, that could be remedied without undoing the dilution, meaning let's assume Mr. McKee is the owner who is in violation of that statute. He can transfer it to me who is not in violation. He's still diluted. Weiser would still be diluted. So the point here is, what was the harm that would have to be, that they're looking to undo here, and it's dilution. But you can't. It's already happened. And so from our perspective...
But isn't that, the problem for us is that your brother says that, well, there's some stuff going on in Canada, and there's reason for us to think that things aren't so set. And what do we do about it? What's our mechanism for dealing with the fact issue?
And that's a fair question. If they're disputing that it closed, that it didn't, if they're saying it didn't close the transaction, or everything we've seen indicates that it did, then I agree with where everybody is, which is, well, then we've got a factual dispute as to whether it is or is not moot. But I don't think you're going to hear that it didn't close. What you're going to hear is, well, we're taking efforts in courts to unwind that transaction. Well, if it closed, it's moot because it's already been diluted. If it's unwound, then what's the harm? Because a Canadian court wouldn't dilute them. It's unfortunate that for them that they didn't get a stay from this court or otherwise stop the transaction from occurring. But at the end of the day, we find ourselves with post-final order, post-judgment actions that have rendered the relief that they seek unattainable at this point. So that's the department's position on this from a regulatory standpoint. It's happened. We approved it. We can't unwind it ourselves. We don't have that authority. All we can tell somebody is, look, you're in violation of the statute, come into compliance or else. So from our perspective, we would agree and we would ask the court to dismiss.
Good afternoon. May it please the court, I'm Steve Menton with the firm of Rutledge Assini on behalf of the appellant Michael Weiser. I think the court's already identified the primary issues here on the motion to dismiss. I think the Goodwin case that's cited in our response to the motion to dismiss is the controlling precedent that determines what this court should be looking at as it relates to the mootness issues. There are 3 exceptions that are recognized within the Goodwin case, and I think this case falls squarely within all 3 of them. First is the collateral issues, which Judge Oosterhuis, you were asking about earlier. At the time that we filed our response to the motion to dismiss, we noted that there were pending proceedings in Canada that directly related to the transaction that's at issue here. Prior to coming today to this court, I conferred with my client and with Canadian counsel again, and those issues are still pending in the Canadian courts. So the direction that I received from my client was to go forward with this appeal because they believe that the ultimate ruling on the substance of the issues raised in our proceeding are relevant to what could happen in Canada. So there are collateral implications of the proceeding that was brought that will continue on, and that resolution on the merits is warranted. In addition to that, the other 2 factors that are cited in the Goodwin case are whether or not it's a matter of great public importance. I think, Judge Thomas, you already raised that. The regulation of medical marijuana is strict in Florida. There are specific prohibitions against dual ownership of MMTCs in this state. It's a very specific statutory provision. It's one that has not, we believe, been fully addressed based upon the record before the Department of Health, and that's what we sought to do through the proceeding that we initiated. We were seeking both to ensure the clarity of what the statutory requirement was, and also transparency to make sure that all the facts that are related to a very complicated transaction in a highly regulated industry are fully laid out and fully considered by the Department of Health, which we don't believe happened in this case. So it is a matter of great public importance in terms of providing some clarity as to what that statutory provision means. And it's also a question that's likely to recur again in the future, which is the third component of the Goodwin test. There are, as I'm sure this court is aware, there's a growing number of MMTCs that are coming into the state. There's more licenses being issued. Exactly how those ownership provisions should be considered, or how they should be considered in the context of the dual ownership prohibition, which is Florida's statutory requirement, is something that is likely to recur and is one that should get clarity in terms of its interpretation.
Now, go ahead, Judge Walker.
Thank you. You've indicated that you meet all three exceptions to the mootness doctrine to keep us with jurisdiction in this case. By doing so, can I presume that you do agree that the appeal is moot and that the only way that we can not grant the motion and dismiss this appeal is if we apply an exception to mootness?
I don't agree that the appeal is moot, because I think that it kind of overlaps with the collateral issue. It has implications, in terms of what goes on in Canada. So the decision that was made by the Department of Health was affirming the ALJ's dismissal of our petition for lack of standing. There was never a full airing of the facts, in our view, that related to the underlying transaction. So this has been dismissed on a technical ground. We don't think that the full factual basis has been fully put forth to the Department of Health or to this court.
And is your choice not to move to stay enforcement of the order, does that not make any difference?
We moved to stay at the Department of Health level. We did file a motion to stay as part of the exceptions that we've submitted, and that was denied. So we did seek a stay. I mean, the client made the decision, I think as part of the evaluation process, not to seek a stay here. They didn't think the likelihood was going to be was great, given the ruling that the Department of Health had made.
So what do you
denying
say
stay.
then to the department's argument that essentially the harm you seek to address is the dilution of your client's ownership? And that's already occurred, and even if it's unwound in Canada, then the harm will disappear.
Well, I think there's two answers to that. One is that if the transaction is actually unwound in Canada, I think that the implications or ramifications of that are unknown. It's beyond my level to understand what would happen in Canada.
But if
as
it
a
were
result of that.
unwound in Canada, would that not mean that, and I may be misreading this, would that not mean then there could not be a statutory violation? There couldn't be dual ownership.
I'm not sure I'm following your question, Judge.
All right, I withdraw it.
But to your early question, I think that the issue also is going to, because it's going to come up again, it's still worthy of resolution both by this court and by the Department of Health.
You mean the generic question of dual ownership
Yes.
and what that means?
Right. So even putting aside the mootness or what would happen in Canada on the collateral issue, I think the issue of great public importance, the clarity as to what the dual ownership prohibition means, is one that should be resolved by this court.
And of course, we don't get to resolve it on this appeal anyway, because it just goes to standing. If you prevailed, it's referred back to the department.
Right. So that we can develop a full factual record and bring forth, the issues that we tried to bring forth earlier. I know that the court's already been here and heard arguments over the time limit before, so unless you have any other questions, I'll save you the time and sit down. And we appreciate your consideration and would ask that you deny the motion to dismiss.
Thank you.
And I've just got a few points. First, I think what you heard is not an assertion that the transaction has not closed, but that the transaction could be reopened theoretically if they prevail on their claims in Canada. Whether or not there actually is a legal avenue to do that or not in Canada, I don't know. But the transaction has closed, as I mentioned earlier. With respect to the mootness exceptions that were cited, again, This is not a question of great public importance. First, I think importantly, Judge Thomas, as you mentioned, the only issue that would actually be adjudicated in this appeal is standing. It's standing and whether or not Weiser had standing to raise his claims in the administrative court. The issue in this case is not how to interpret the dual ownership prohibition in Florida's medical marijuana statute. The department reviewed, with respect to that question, the department reviewed in detail the filings here, the shareholders, and whether or not there was a dual ownership violation, and determined that there was no statutory violation. Certainly, that's a legal issue that individuals who practice in marijuana law might be interested in, but it's a relatively arcane legal issue, not one that's truly of great public importance. I would also submit that it is not capable of repetition yet evading review, which is typically the exception to mootness. Certainly, it can be adjudicated at a later time if necessary. Essentially, it would be an advisory opinion. Any decision by this court on the dual ownership prohibition would I would submit be an advisory opinion. That's all I have, Your Honor, so unless there's other questions, I'll ask that this court dismiss for mootness.
Thank you both for your arguments.
Thank you.
Court is in recess.